series focusing on the historic case in Dover, Pennsylvania that was decided this last December. Most of the expert witnesses speaking. Our next speaker is Barbara Forrest from Southeastern Louisiana University, who was the expert to talk about really the detailed connections between creation science and intelligent design. So without further ado, Barbara Forrest.
Thanks, Rob. I am, as you can see, labeled as a hybrid expert. That comes from Judge Jones. He called me that because I had kind of a unique position in the trial. I was the only one that the other side tried to get kicked off, and I'm going to explain how that worked. But on being a hybrid expert, that actually comes from Judge Jones's decision. And so I'm going to explain, a little bit of what I had to do and how that worked out during the trial. Want to, though, before I start, say that the people that we really need to thank, as Rob has done, and I would like to do, are the Miller plaintiffs, because if it hadn't been for what they did, none of us would have gotten to make any contribution to the trial at all. So these are their pictures. I don't have pictures of all of them. There were 11 altogether. That's an extraordinary number of plaintiffs for to come from a small town like Dover. But these people really were the ones who deserve the real credit. And the reason they were in the position they were in ultimately, it goes back to what the people at the Discovery Institute's Center for Science and Culture have been doing now for over a decade. If you need just a little background, and you probably know a lot of it, but the Center for Science and Culture is the creationist arm of the Discovery Institute. And there you see the chief players at this institution. There's Bruce Chapman doing what he does best, talking to the media. And that's pretty much what these people are really good at. There's Michael B. talking to the media outside the courtroom. There's William Dembski. You see in the lower right-hand corner the father of this movement, Philip Johnson, with Chuck Colson, the convicted felon of Watergate fame, now runs Prison Fellowship Ministries. And there's Jonathan Wells, the author of Icons of Evolution, in his younger days in front of the Unification Theological Seminary, where he was studying under the mentorship of Reverend Sun Myung Moon. And here he is today, wiping out Darwinism, or devoting his life to destroying Darwinism, which is why he got his second Ph.D. in biology at the behest of Father Moon. So it's the work that these people have been doing, which ultimately produced the lawsuit in Dover. And so this is, they literally lie at the root of everything that we're doing here today. Their program is called, that they have a strategy. They have no science, as you know, but their strategy is called the Wedge Strategy. And if you saw the page, the picture on the first slide I had, that is the cover sheet of the document called the Wedge Strategy. I'm going to talk a little bit more about that document. But what the strategy is about, Philip Johnson came up with this, it's based on the metaphor of a wood-splitting wedge. What they want to do is to kind of, as he says, break open the log of scientific materialism and slip into the definition of science the idea that the supernatural can be appealed to as a scientific, as part of the definition of science, so that it can be used as a scientific explanation. This is their wedge strategy. And my involvement in the trial is really, it starts with this document, because my book is an examination of how they are executing the strategy. But this is what the strategy is about. Change the definition of science. One of the things I learned in my research was that when Philip Johnson read the Edwards versus Aguilar Supreme Court decision in 1987, he decided, well, the reason the creationist lost is because of the way science is defined. We simply have to change the definition of science so that the supernatural is not a priori, in an a priori fashion, arbitrarily excluded. So that's what the wedge strategy is about. And it's aimed at the public and at policymakers. And this is what got me called into the trial. The book that my co-author, Paul Gross, and I produced is really an outgrowth of the first article that I wrote on the wedge strategy. It's Rob Pennock's book, Intelligent Design, Creationism, and Its Critics. The Wedge document, I'll explain in a minute a little bit about that, but the Wedge document, as it's now known, lays out a 20-year strategy, what these people hope to accomplish over a period of 20 years. And what I learned in looking, first I had to authenticate the document, which I did. And what I learned in reading through the document and in doing research was that they were executing every aspect of the strategy except the one that is fundamental to it, which is listed in phase 1, and that's doing science. So that research produced this book, Creationism's Trojan Horse, and that's what got me called into the trial. And there's my website, creationismstrojanhorse.com. You can read my expert witness report and the supplemental report that I had to write. It's on a page that's linked off this main page. You can read a lot of things about the trial. You can see the demonstratives that we used to show the judge on the computer screen in the courtroom. This document was drawn up by the Discovery Institute probably in 1996 when the Center for the Renewal of Science and Culture was first formed at the Discovery Institute. It was revised in 1998. It was to be used as a fundraising tool, and you can see there that they outlined 3 phases. The first phase is scientific research, writing and publicity, phase 2, publicity and opinion making, phase 3, cultural confrontation and renewal. Needless to say, they didn't follow the order of the phases in carrying out the strategy. But for what I was able to do was to authenticate that this document was really theirs. They didn't want to acknowledge it outright, and I found material on their website in a directory that was not available to the public anymore, material that confirmed that this was their document. And after I wrote about it, they did finally acknowledge it. And just a few months ago, after Judge Jones gave his opinion, the person who leaked the document, Matt Duss, who was anonymous for all these years, made his identity known, but the person who posted it was Tim Rhodes. And I contacted him early in my research, and he gave me the electronic scans of the original document. And so I had them to work with during my research, and this is one of those pages that outlines the phases of the strategy. I'd like to start with my deposition. I was deposed in New Orleans on June 6th, 2005, and the person who deposed me was the lead attorney, the executive director of the Thomas More Law Center, Richard Thompson. They had been in the intelligent design camp for some years. There you see a little bookmark, 10 questions to ask your biology teacher about evolution that they produced to give to school children. So Richard was there. Aaron Rothschild was with me because he's the attorney who prepared me for the trial. And the other person was there was William Dembski, who came. He's one of the lead people in the intelligent design movement. He came as Richard Thompson's advisor. He wasn't allowed to question me directly, but he could advise Richard Thompson and give him notes and questions to ask. And you see, he sort of looks like he has a frown on his face. That's about how he looked when he showed up in New Orleans at my deposition. I did not know he was going to be there. He comes in really frowny faced, glowering and prepared to be, not happy, not pleasant, and I just did my Southern Magnolia routine on him and made him shake my hand. And by lunchtime, he was actually having to try to suppress a smile. He was beginning to relax. We were there from 9 to 4, but I guess he got bored. He left at 1:30. Anyway, this was my deposition. Now, what's interesting is I'm going to show you the next slide. When Dembski was there on June the 6th, he, of course, had a couple of weeks earlier, had been complaining about the fact that the scientists didn't show up for the Kansas hearings that had been held in early May. The scientists all over the world boycotted the invitation by the Kansas Board of Education to show up and debate the science standards. And he comes up with this funny little thing on his blog. He calls it his vice strategy. What he would love to do, he says, to get these people, get these Darwinists under subpoena and just, have them sit down, but they can't avoid the questions. And he proposed a strategy, as he says, for interrogating the Darwinists to squeeze the truth out of them. And of course, he had put this up a couple of weeks before he was at my deposition. And so this is going to figure in a little bit later in something that I'm going to tell you, so remember this. Anyway, this is the roster of expert witnesses. And what's interesting is you have Dr. Beebe, Dembski, Warren Nord, who was an intelligent design supporter, UNC Chapel Hill, Dick Carpenter, works for Focus on the Family, John Campbell, John Higgins Campbell, Stephen Meyer, Steve Fuller, and Scott Minnick. What was interesting is that Dembski was supposed to be deposed exactly a week after I was. And what happened was that, one by one, some of the lead witnesses began to withdraw. Dembski withdrew before he was deposed. Stephen Meyer withdrew. John Higgins Campbell withdrew 5 minutes before his deposition was supposed to start. Warren Nord was withdrawn before he testified. Dick Carpenter was withdrawn before he testified. So that left them with only 3 expert witnesses. And I find this very interesting because here was Dembski's golden opportunity. He had the Darwinists under oath, right? You know, where he could help turn the screws on the vice and squeeze the truth out of us, and he withdrew. He just simply did not participate. He had us right where he wanted us, right? And didn't take advantage of it. So there was another person that I think, well, I know that the other side would like to have had disappear, and that was me. After I was deposed, later in the summer, the defense filed a motion in limine, which means a motion to eliminate a person from a legal case. And that's what they did. They filed a motion, and there was a brief that accompanied the motion. This was filed on, I think it was September the 6th. So I had my ticket, I was practically packed. This was in the immediate aftermath of Hurricane Katrina. On September 6th, I was without power, sitting in a south window of my house where there was light trying to get ready for the trial, and all this was going on. And so the Thomasboro Law Center filed a brief to accompany the motion in which they were trying to get me eliminated on the basis of the Dow versus Merrill Dow Pharmaceuticals decision, in which the Supreme Court ruled that when you have a case in which there's expert testimony coming from scientists, the judge has to make a determination at the beginning of the trial whether the methodology that was followed was appropriate, whether the scientists are genuine experts. And they tried to get me thrown out from the case on the basis of that. But I had not been called as a scientific expert. I'm not a scientist, but that was their reasoning. But that's not the only reason. They also like to point out, that they did point out, that I was a little more than a conspiracy theorist and a web-surfing cyber stalker of the Discovery Institute. And so this really comes from William Dembski. Even though the Discovery Institute and the Thomasboro Law Center was squabbling behind the scenes over various things, this comes directly from Dembski. He had accused 2 of his critics earlier of stalking him on the internet, and so this comes right from William Dembski. So I can see that they had a hand in this. And also, I'm going to show you something else that they did, but I want to remind you that the Discovery Institute, the Center for Science and Culture, is the organization that says that they're going to revolutionize the scientific world, right? According to Meyer, they're in the initial stages of a scientific revolution. According to Dembski, this is a full-scale scientific revolution. So after the motion was filed, I was waiting for the decision, and I was stuck at home. After Hurricane Katrina, there was another hurricane, Hurricane Rita. And I was stuck in Baton Rouge, couldn't get out, so I was checking the Discovery Institute website every day and getting ready for the trial. And on September 29th, when I should have been at the trial, I wasn't, got there the second week, this is what went up on their website. I was reading this and I said, geez, they have a transcript of a radio interview that I did, but then I realized I didn't do this. It's a fake interview between Dr. Barbara Forrest, and they placed me at Louisiana State University, and I'm sure they know that that was not right. But between Dr. Barbara Forrest and a fictitious radio host named Marvin Waldberger. And this, I don't know, I just have to hope that the judge was surfing the internet and saw this, but this is the organization that claims to be revolutionizing science, and this is what they did to ridicule me in advance of the trial. And so this is, part of the effort when they couldn't get me thrown out, the judge ruled on September 22nd that I could come up there and I could be a witness. And when that didn't work, when the effort of the Thomasboro Law Center didn't work, this is what the Discovery Institute resorted to. So what the judge did, Judge John Jones, was I was on the stand for a day and a half, and we spent the whole first morning of the first day fielding off the challenge to my being qualified as an expert witness. He finally called me a hybrid expert, because strictly speaking, I'm a philosopher. But philosophers don't do everything at the abstract level, and I had spent 3.5 years doing a lot of empirical research to document the fact that intelligent design is creationism and that it's religion, and I had used their own words to do it, and that's what's in the book. But calling me a hybrid expert, functioning as a historian in an area of blazing new territory, he did admit me as a witness, and after lunch on that first day, I was able to begin really sharing with the judge what I knew about the intelligent design movement. I had, and these are all the plaintiffs. You see me and Rob and Kevin Payne and Professor Todd, Ken Miller, Jeffrey Shallett, who was a rebuttal witness for Dembski, didn't have to testify because Dembski withdrew, and then we have Brian Alter, so that left us with 6 expert witnesses. And of course, the National Center for Science Education as a pro bono consultant. And Nick Matsky, who's in the picture there, was really indispensable to me because he helped me go through a lot of material. So these are all the people that we had mustered against the other side, who only had 3 expert witnesses left. And these are our attorneys, fiscal attorneys. There you see them from the ACLU, from Americans United, and the Pepper Hamilton Law Firm. What I had to do was 2 things. I had to testify about the Wedge Strategy and show the judge that this explained the strategy. I literally walked him through the document, explaining the phases of it, the opening of it, and then the second thing I had to do was to testify that A People in Pandas is a creationist textbook. I had subpoenaed documents that were subpoenaed from the Foundation for Thought and Ethics, which holds the copyright to pandas, and had produced this book. And so I had to do these 2 things. I had to show that this was a creationist text and that the Wedge Strategy is a creationist strategy to promote what is essentially another version of creationism. And so this is the first page of the document, along with the phases again. And what I had to outline for the judge were the important parts, and really the very first sentence, which was the first thing I read to him, shows the creationist nature of this movement, the proposition that human beings are created in the image of God is one of the bedrock principles on which Western civilization was built. And I literally walked him through this document. It was projected onto a large screen. He had it on his monitor so everyone could see it. And one of the things that we focused on very strongly is one of the phases of this strategy is they want to develop intelligent design through the use of apologetics as seminars. Well, what is that? It's very important. Apologetics is an exercise that Christian, for example, Dembski does this. It is a response to what they perceive as attacks on Christianity, where they develop arguments to respond to what they perceive as attacks. And this is specifically one of the avenues which they themselves say in their strategy they're going to use to promote intelligent design. So this is the type of stuff that I was presenting on the witness stand in court. And now you can see, now Rob used the same 2 quotes, and the fact that we both used them in court, you can see one of the reasons that they wanted to keep me off the stand, because Dembski knew exactly what I was going to say, having been at my deposition. They had my expert witness report. They knew exactly what I was going to say during the trial. They knew that I would tell the judge that intelligent design is creationism, that it's religion, and that really, if you'd only had these 2 quotes, this was enough to establish it, that Dembski defines intelligent design as the logos theology of John's Gospel, restated in the idiom of information theory. That not only defines it as a religious belief, but as sectarian Christian belief. And there you see the quote from Philip Johnson, which Rob also used. He defines intelligent design as theistic realism. And so that is pretty clear. Using the words of the leaders of this movement, that's all you need to establish that it's not only religious, but that it is also sectarian. But the real savior, what I like the best, is one that I found one day sitting in the law office preparing to work with the attorneys in Philadelphia, and I was amusing myself while Eric had to go off and do the kind of law that pays his bills. And I was reading Touchstone magazine, which is a religious magazine which has devoted a lot of attention to promoting intelligent design. And there was an interview in the August 2004 issue with Paul Nelson and William Dembski and Philip Johnson. And Paul Nelson actually states in this interview, it's incredible, that the question was something like, what is the biggest challenge facing intelligent design now? Remember, this is only a year and a half ago, not quite 2 years ago, that he said this. And he says, and I still can't believe they let him get away with it and put it in print, Easily the biggest challenge facing the I&D community is to develop a full-fledged theory of biological design. We don't have such a theory right now, and that's a real problem. Keep in mind now that this is 2004. This is 13 years after Philip Johnson wrote Darwin on Trial. Right? And many years after Dembski said in 1998 that this is a full-scale, this is a fully cashed-out scientific theory. To continue, without a theory, it's very hard to know where to focus your research, to direct your research focus. Right now, we've got a bag of powerful intuitions and a handful of notions such as irreducible complexity and specified complexity, but as yet, no general theory of biological design. Duh! I mean, I could have just given the judge this, and I don't think he would have needed anything else, but there was lots more. I was on the stand for a day and a half, so this was very effective. The other thing I had to do is to look through all of these 7,000 pages of subpoena documents. One of the things that our archivist at the National Center for Science Education did was to find an old clipping from 1981 in which in an old Creationist student newspaper showing that someone was looking for people to participate in the writing of a creation evolution textbook, and one of the people involved was Charles Thaxton, who's one of the founders of this intelligent design movement. Taking that old clipping, the lawyers thought, well, maybe there are drafts of the book, and they subpoenaed all the documents related to the book, and sure enough, the Foundation for Thought and Ethics had kept all of these drafts over the years, and so I had to testify about what I found in these documents, and Nick Matsky helped me go through them, and I'll show you what we found. Oh, what's interesting is that Dean Kenyon, who was a Discovery Institute fellow, he's one of the co-authors of this book, and I found a letter in those documents showing that in 1986, he was writing to John Buell at the Foundation for Thought and Ethics about working on this book, which became Canvas, and at the same time, he was one of the participants in the Edwards case as a creation scientist. He had filed a sworn affidavit arguing that creation science was just as strong as evolutionary theory. So he was functioning as in both capacities at the same time. And there you see the two gentlemen who were responsible for problems with this textbook. So what did I find looking through the drafts? There were at least 5 drafts. The first one was a 1983 draft written on an old typewriter, the Creation Biology Textbook Supplement. That was the first one we found. The second one was called Renamed Biology and Creation, dated 1986, and you can see Dean Kenyon and Percival P. William Davis, was Percival Davis' name on there. The next one was 1987, Biology and Origins, but in 1987 they changed the name of the book to Of Pandas and People. This was the one 1987 version, there were 2. The other one, of course, was the Intelligent Design version. Now, how did we know this? Because in the second version, all of the creationist language, which was very explicit, was taken out, and the term intelligent design and various cognates of that term were used in replacement of creationism. But how did we know how significant it was? Well, the way we knew how significant it was, so one night I was going through these documents and I saw in the version in which the creationist terminology had been taken out and intelligent design put in the introduction was a footnote referencing the Edwards decision. In the earlier 1987 version, that footnote was not there. And so I knew then that they had changed the second version in the aftermath of the Edwards decision, because they were going to try to promote this textbook as something other than a creationist book. So we made a timeline for the judge, showing him the first version, pre-Edwards version, and the post-Edwards version, and then the published version, which was identical to the post-Edwards version. The other thing we did was to show him the definition of creation in the old drafts, and of course it reads in terms of abrupt appearance. Creation means that the various forms of life began abruptly through the agency of an intelligent creator with their distinctive features already intact, fish with fins and scales, birds with feathers, beaks, and wings. This is the classic definition of creation as a creationist would give it in terms of abrupt appearance, implying direct intervention, divine intervention, producing fully formed animals. And in all the versions, except the published version and the post-Edwards version, that creationist language was in that definition, but in the fourth one, in the published version and in the 1987 post-Edwards version, the definition was left intact, except as you see in red, the intelligent design was used to replace creation. That was the only difference. Another thing was that in one of these drafts, of course, you can see this is the type of language in which the book was written. But when they switched from using old typewriters to word processors sometime during the 80s, you could see the difference, and they had gone in and done a search and replace to cleanse out the old creationist terminology. But in one draft, they didn't quite get it out. And you can see that design components, you have the C for creationism in front of design and the ISTS in the back. And so, of course, that is called the missing link. It's another reason you can see why they didn't want me on the stand. They knew I had all these documents. What Nick Matsky did, bless his little pea-picking heart, he took the raw ASCII files, he and Leslie Ellsbury, they did a word count to show that the words in these drafts tied them all together. But we saw that they did a word count in the first 1987 version, counted the words, the times creationism and its cognates were used. And then in the second version, they did a word count. You can see the abrupt shift and the incidence of these words being just switched out like this. And this, we used this in court. This is one of what we call our demonstratives. And you can get this on my website, www.creationismstrojanhorse.com. You can also get the chart that I made that we used in court to show that intelligent design is a direct descendant from the earlier creation science, using quotes to show that. You can get that on my website. And then, of course, on December 20th, we won, which was a wonderful day. And there you see the plaintiffs high-fiving and being deservedly happy. And the Discovery Institute response was very interesting. Dembski, of course, had his priorities in order. And since this galvanizes the Christian community, we're going to be raising a whole lot more funds now. Judge John West, though, the Associate Director of the Center for Science and Culture, immediately attacked the judge. And this new book that they put out called Tracing into Evolution is a summation of all the attacks on the judge that they wrote in the immediate aftermath of the trial. But this was the response of the Discovery Institute, and they've been attacking the judge ever since. That has really not stopped. But what's interesting was that Dembski, of course, remember his vice strategy, where he wanted us under subpoena, under oath, he could squeeze the truth out of us. He was the one who welched out. But after he quit, he wanted payment. All of these people were doing it for money. We did it all pro bono. Dembski was charging $200 an hour. And he threatened to sue the Thomas More Law Center for the money that he said that they owed him. He was charging $200 per hour. He said he had done 100 hours of work. He collected $20,000 for not showing up. So this was an interesting aftermath. But, of course, we had the victory, and Judge Jones gave us a better decision than we could have had if we had written ourselves. That ID cannot uncouple itself from its creationist and religious antecedents. The defendant's ID policy violates the Establishment Clause of the First Amendment of the Constitution of the United States and the Constitution of the Commonwealth of Pennsylvania. And when he was interviewed later and informed of the attacks and the challenges to his opinion, he said quite rightly that the opinion speaks for itself. It really needs no embellishment. But it's interesting to see where the intelligent design movement has gone in the aftermath of the Dover verdict. One of the things that I predicted that they would do, and what they have done, is to move to the hard right. They don't have very much fertile territory left for cultivating, disciples, and so they have moved to the hard right. Dembski has forged an alliance with the Lubavitcher Jews, which are the very orthodox Jews who are embracing intelligent design. But he also has a new ally, and that is Ann Coulter, whose new book, shall I name it, Godless. Dembski takes credit for helping her with the 4 chapters that she devotes to Darwinism. He put on his weblog, I was in constant correspondence with Ann regarding her chapters on Darwinism, and he labels her, Ann Coulter, the wedge for the masses. So, the only thing I can think of to say is to quote Dave Barrett and say, I am not making this up. Thank you very much.
why did they withdraw from deposition, and could the plaintiffs have contact as people
one of the things that was going, from the very beginning, the Discovery Institute did not want this case. They did not initiate it, and one of the problems was that they couldn't control it. They were not in control of it. The Thomas More Law Center had been, on its own, trying to stir up a case of intelligent design as well. The Discovery Institute has wanted a legal case for years. They published a law review article detailing their strategy. But since the word intelligent design is now a liability, they didn't want this case because it was explicitly crafted around that term. And they tried to get the Dover School Board to either rewrite the policy and take that term out or withdraw the policy, and they couldn't get that done. They really didn't want this case. But they were caught between a rock and a hard place. If they didn't participate, it would look like they either couldn't or wouldn't defend their own ideas, and if they did, they risked a legal defeat. So that there was that difficulty for them at the very beginning. What was happening behind the scenes was that, and we still don't know all the details, but there was some squabbling between the Discovery Institute people and the Thomas More Law Center. Dembski and Meyer and John Angus Campbell wanted to bring their own attorneys into the case to represent them independently of the Thomas More Law Center. The Thomas More Law Center is a very small organization. They only had about four attorneys. And they understandably refused to go along with that. And when they could not continue with their own attorneys, they withdrew. They said, we're not going to go any farther unless we've got our own attorneys. And so they just simply refused to play, which constituted their withdrawal. And they, I think were very concerned that they were not going to be adequately defended by the Thomas More Law Center, so they withdrew. They did try to get back into the case. John Buell of the Foundation for Thought and Ethics, when Dembski was still in the case, as everybody had written expert witness reports, including Dembski, they regarded him as looking out for their financial interests regarding Canvas, because Dembski is working on a revision of Canvas called The Design of Life. So he was there as sort of, looking out for that angle of it. And when he was no longer there, Buell tried to file a motion to intervene to get into the case as a defendant so that he could look out for his financial interests. And the judge said, you can't do that because you've had all this time, you've made no motion to intervene, you can't do that. So that left them with really nobody looking out for them. So it seems to be that they withdrew for a number of reasons. They couldn't have their own attorneys, and I think they saw a legal defeat coming. I think they knew what all of the expert witnesses for the plaintiffs were going to say. They knew exactly what was going to happen. And Dembski had accused the scientists who boycotted the Kansas hearings. He said they just, boycotted because they just wanted to escape the critical scrutiny of cross-examination. If you want the real truth as to why they pulled out, they did not want to be cross-examined. They didn't want to be under oath on the witness stand under cross-examination. And that's the real reason, I think. In the back.
It seems like the creation side made a lot of mistakes in that you were able to capitalize on. Are you worried that this comes up again and you'll fix a lot of mistakes when you get to the next, or the next trial off of it?
Well, there's one big thing they can't fix, and that is that they don't do any science. And they can't fix the fact that they're creationists. I mean, all of this is now on the record. I don't know what they can do except to try to sanitize their language even more, which I think they started doing this a couple of years ago. And so they're going to now start advocating, in addition to teach the controversy, teaching the strengths and weaknesses of evolution, teaching, they want the students to learn the critical analysis of evolution. They're going to use various euphemisms. That's going to be their next strategy. But that strategy was evolving even prior to the trial when they ran into resistance in Darby, Montana, and in Ohio. So you can kind of foresee where they're going to go. They have no other way to go except to sanitize their terminology to try to fool a federal judge. And they really do want a lawsuit. They just didn't want this one. They want a lawsuit in an area. They wanted one in Ohio. They didn't get one. I think they'd love to have one out of Kansas, but they want a lawsuit where they control the terminology, where the Discovery Institute controls that, where they control the players on their side, including the attorneys, and where they really think they own the federal judges. What's really interesting was on Dembski's blog on September 30th, Dembski was, sort of hedging his bets as to where the trial was going to go. He said that there was a 70% chance that the judge would just rule against the policy and leave intelligent design intact, and then, having the case completely thrown out was a very low probability, and that type of thing. And one of his favorite bloggers, he says that one of his favorites is a guy who goes by the pseudonym of Dave Scott, said, be optimistic, Dave. This is politics. This is all about Judge Jones. He's a good old boy appointed by GW himself. That's how he wrote it. And we just, need to have faith because there's no way he's going to rule against his political allies. And so I think some of the people like Dave Scott thought they had it in the bag, and they thought they owned this judge, and they got fooled. But what the Discovery Institute has been doing for years is shopping around for a conservative enough judicial district where they think they really do own the judges. And they will try to go in there with as sanitized a version of intelligent design as they can produce. And that's what we're watching.